Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about assumption of the risk and Kansas City Royals baseball. Stay tuned. Well, I have been a lifelong baseball fan, and something I don't think everybody in the country understands is that one of my very favorite announcers, a guy by the name of Harry Carey, the late Harry Carey, was not always the Cubs announcer. For many years, particularly in the early 1960s through about, I think, 68, he was the announcer for the St. Louis Cardinals. In those days, we didn't have any ESPN. We didn't have the MLB network. Satellites were things like Telstar, and as a result, if you couldn't get it on the rabbit ears, you didn't see it on television. When we wanted to hear baseball, we wanted to experience baseball living in the rural part of Missouri, well, we had one opportunity to do that, and that was with a radio. And of course, we listened to the radio and we listened to the calls made by the announcers. And I didn't realize it at the time, but a lot of the time the announcer would take something like a hammer or maybe a pair of scissors, and he would say something like, "Swung on, there's a line drive." And you would hear that whack and you would think, wow, the microphone just picked up that guy hitting the ball. Except it didn't. But that was what they did to make baseball interesting and fun in the 1960s. And of course, Harry Carey was at the heart of that. And one of the things that I loved about Harry Carey was that he made intensely exciting moments that much more intensely exciting. So in the 1960s, I basically listened to every baseball game that I wanted to listen to. And at the time, the Cardinals were the dominant radio network where I lived. But later on, in 1969, the Kansas City Royals came along, and I became a lifelong Royals fan. I've been a fan of the Royals ever since they were created in 1969. It was a great thing for me in 1985 when they won the series, and again a few years ago, I believe it was 2017 when they won. It's been a lot of fun for me to follow baseball, and that's why this particular case was so interesting to me. Because many times when I've gone to see Royals games in Kansas City at Royal Stadium, I have seen Slugger, the team mascot. And I've seen Slugger do something that I think only Slugger does, and that is use a hot dog gun to shoot hot dogs up to the fans in the stands. And when Slugger didn't shoot them up with his hot dog gun, sometimes he just tossed them up gently to the people who were watching. And out of one of those comes this particular case for an injury to an eye from a flying hot dog. This is a case where early on the trial court made an error and determined that the issue of whether there was assumption of the risk was a jury question. It is, in fact, under the law, a legal question and one that should have been answered by the trial court. But he made that determination. It went through the trial court process. A verdict was reached, and the jury apportioned 100% of the fault to Mr. Coomer, an individual who was struck in the eye by a flying hot dog. Yes, you heard that right. So let's pick up with the background of the case. This is the Supreme Court case that ultimately decided the issue. Let's pick up with that, and it will tell you the story of how Mr. Coomer didn't relish his hot dog. So here's the story on what happened. Coomer is a longtime baseball fan. He went to a game between the Royals and the Detroit Tigers. There were only about 12,000 people on hand, so it must have been a weeknight. With such a small crowd, Coomer and his father left their assigned seats early in the game and moved to empty seats 6 rows behind the visitors' dugout. Shortly after Coomer changed seats, Slugger, the mascot, mounted the visitors' dugout to begin the hot dog launch, a feature of every Royals home game since 2000. The launch occurs between innings when Slugger uses an air gun to shoot hot dogs from the roof of the visitors' dugout to fans seated beyond the hand-tossing range. When his assistants are reloading the air gun, Slugger tosses hot dogs by hand to the fans seated nearby. Slugger generally tosses the hot dogs underhand while facing the fans, but sometimes throws overhand behind his back and sidearm. Now, Coomer estimates he's been to about 175 games, and he's watched this happen numerous times. He says he and his father were seated about 15 to 20 feet from Slugger, directly in his view, and after employing his hot dog-shaped air gun to send hot dogs to distant fans, Slugger began to toss hot dogs by hand to fans seated near Coomer. Coomer testified that he saw Slugger turn away from the crowd as if to prepare for a behind-the-back throw, but because Coomer chose that moment to turn and look at the scoreboard, he admits he never saw Slugger throw the hot dog that he claims injured him. Coomer testified that only a split second later something hit me in the face, and he described the blow as pretty forceful. Coomer did not report this incident to the Royals when it happened because he did not realize he'd been injured. Instead, he stayed for most of the rest of the game, a thrilling 7-5 effort that snapped the first-place Tigers' 6-game winning streak, and even returned to Kauffman Stadium the following night to witness the Royals' further 5-1 drubbing of the Tigers. Thursday morning, however, Coomer felt his eye was seeing different and something wasn't right, so he went to the doctor, was diagnosed with a detached retina, and then developed a traumatic cataract in the same eye. Coomer reported his injury to the Royals in September of 2009, 8 days after it occurred, and filed this lawsuit alleging 1 count of negligence and 1 count of battery. Now they drop a footnote here. The trial court dismissed the battery claim in a partial summary judgment, and Coomer does not appeal that dismissal. Regarding the negligence count, Coomer asserted that the Royals, through its employee, Slugger, failed to exercise ordinary care in throwing hot dogs into the stands, that the team failed to adequately train Slugger on how to throw hot dogs into the stands safely, and that the team failed to adequately supervise Slugger's hot dog toss. In its answer, the Royals admitted responsibility for Slugger's acts, but denied he'd been negligent. The Royals also asserted affirmative defenses of assumption of the risk and comparative fault. The Royals employee who portrays Slugger, Mr. Shores, testified at trial he did not remember the throw that allegedly injured Coomer. He admitted that the Royals had given him no specific training on how to toss hot dogs, but testified he was aware that fans could be hurt and that he was careful in making his tosses. For example, when a fan is seated nearby, he tries to make eye contact before tossing a hot dog so the fan knows it's coming. In addition to hearing Slugger's testimony and Coomer's description of the incident, the jury heard testimony from another fan who claimed to have been injured by a hot dog toss from Slugger under similar circumstances. At the close of the evidence, Coomer moved for a directed verdict on the issues of comparative fault and assumption of the risk. He argued that implied primary assumption of the risk only applies to risks that are inherent in the nature of the activity. And in this case, the harm of getting hit with a hot dog has absolutely no relationship to going to a baseball game. Regarding comparative fault, Coomer argued that, as a matter of law, he cannot be negligent merely for not fleeing his seat during the hot dog launch. The trial court overruled Coomer's motion, holding that both A, whether the risk of being injured by Slugger's hot dog toss is one of the risks inherent in watching a Royals game, and B, the reasonableness of Coomer's actions were both proper questions for the jury. In preparing the jury instructions, the Royals proposed adding a tail to instruction number 9, the verdict director for Coomer's negligence claim. Instruction number 9. In your verdict, you must assess the percentage of fault to the defendant if you believe, first, defendant's employees threw a hot dog that hit plaintiff, and second, defendant's employee was thereby negligent, and third, as a direct result of such negligence, plaintiff sustained damage, unless you believe that plaintiff is not entitled to recover by reason of instruction number 11. Instruction number 11 says, in your verdict, you must not assess the percentage of fault to the defendant if you believe, first, the risk of suffering an injury by being struck by a hot dog thrown in a manner in which slugger threw the hot dog that plaintiff alleges struck him was a risk inherent in attending a game at Royal Stadium, and second, plaintiff comprehended the actual risk, and third, the plaintiff intelligently accepted the risk. Coomer objected to instruction number 11 and the tail on number 9 on the grounds raised in its directed verdict motion. In addition, he objected to the proposed comparative fault instruction. The trial court overruled his objection. The jury verdict returned a verdict in favor of the Royals. The verdict states the jury assessed 0 fault to the Royals and 100% of fault to Coomer, but it does not disclose the basis for this decision, as you wouldn't expect. So, the court reviews claims like this for instructional error de novo, meaning that they can overrule the trial court on that. They're not going to vacate a judgment on the basis of error, however, unless the error materially affected the merits of the outcome. This case presents the question of whether the century-old affirmative defense, commonly referred to as assumption of the risk, survived this court's adoption of comparative fault in Gustafson versus Benda. To the extent it survives, Coomer claims that the application of this doctrine is to be decided by the court and not the jury. The court agrees. Because the trial court erred in submitting the question of assumption of risk to the jury, the judgment in this case must be vacated and the matter remanded. Now, at this point in the case, we know that the case is going back to the trial court, but in order to help the trial court, the Supreme Court is going to spell out the law on this issue of assumption of the risk. And they get down into the nitty-gritty of it. And so I will try to cut to the piece where it actually makes a little bit more sense and give you a little bit of a respite from the long technical reading in the opinion. It said it's safe to say that the judicial analysis and application of assumption of the risk has not always achieved high marks for clarity and precision. Boy, is that an understatement. Historically, courts often failed to draw or maintain important distinctions between this doctrine and defenses such as contributory negligence, which, though they may have seemed similar to assumption of the risk, were quite different. Admittedly, those distinctions seldom made any difference as a practical matter because any of these often overlapping defenses was sufficient to bar completely all recovery by the plaintiff. At least this was so before the advent of comparative fault. And this is where the history comes in, because prior to the advent of the doctrine of what is now called comparative fault, we had contributory negligence, where if the plaintiff was in any manner responsible for the harm that ensued, then it was a complete defense and the plaintiff could not recover. So, for example, if someone was trying to sue for a slip and fall on the ice, and one of the things that they did was they wore flat dress shoes instead of snow boots, you could allege that they were contributory negligent, and as a result, they couldn't recover. Comparative fault now just allows the jury to say, well, he's 10% at fault for wearing these, flat-bottomed shoes, but the store is 90% at fault because they let all of this ice build up and never tried to take it down, or they tried to take it down incorrectly, or whatever the case may be. But the difference is that a little bit of negligence on the part of the plaintiff no longer bars a complete recovery in the state of Missouri. The basic principle of this defense is easily stated. If a person voluntarily consents to accept the danger of a known and appreciated risk, that person may not sue another for failing to protect him from it. In practice, however, this principle proved easier to state than to apply. So now I'm going to jump back to the first part of the opinion because it explains this in a way that doesn't quite go to the depths that the technical explanation does. Coomer sued Kansas City Royals baseball, claiming the team is responsible for his negligence. A jury found in favor of the Royals. He appeals. Among the jury instructions was one asking the jury to decide whether the risk of being injured by Slugger's hot dog toss is one of the inherent risks of watching a Royals home game that Coomer assumed merely by attending. Whether a particular risk is inherent in watching a sporting event is a question of law for the court, not a question of fact for the jury. This court holds that the risk of being injured by Slugger's hot dog toss is not one of the inherent risks of watching a Royals home game. In the past, this court has held that spectators cannot sue a baseball team for injuries caused when a ball or bat enters the stand. Such risks are unavoidable, even desirable, part of the joy that comes from being close enough to the great American pastime to smell the new mown grass, to hear the crack of 42 inches of solid ash meeting a 95-mile-per-hour fastball, or to watch a diving third baseman turn a heart-rending triple into a soul-soaring double play. The risk of being injured by Slugger's hot dog toss, on the other hand, is not an unavoidable part of watching the Royals play baseball. That risk is no more inherent in watching a game of baseball than it is inherent in watching a rock concert, a monster truck rally, or any other assemblage where free food or t-shirts are tossed into the crowd to increase excitement and boost attendance. Accordingly, John Coomer's claim is not foreclosed by the assumption of the risk doctrine. Instead, it is up to the jury to decide 1. Whether Slugger injured Coomer by hitting him with the hot dog, and 2. Whether Slugger was negligent in doing so. If so, the jury is entitled to hold the Royals liable for Coomer's damages, and the jury is entitled to reduce those damages by whatever percentage of fault the evidence shows should be assessed to Coomer. Because the jury instructions given below introduced an improper consideration into this otherwise ordinary analysis, the court vacates the judgment in favor of the Royals and remands the case. Now, the Supreme Court took that case after the Western District had issued a very similar opinion, but the Kansas City Royals took it up and asked the court to transfer it, and the court basically reached the same decision that the Western District did in that case. And so they sent it back to the trial court. The trial court did another trial. And now, as Paul Harvey would say, for the rest of the story. And that is this. On a second trial, Mr. Coomer lost again. Because I think pretty much most people would understand that a hot dog tossed underhanded at you and in an arc, as that one was, is really fairly unlikely to cause the kind of damage that he claims was caused. And even if it was, you have to prove he was negligent, that he threw it in some way that breached a duty of care to him. And I don't think they ever had evidence of that in this case. And so whether it's because they didn't buy into the whole idea of being injured by a hot dog, or they didn't buy into the whole idea that a mascot can be negligent simply by throwing free stuff into the crowd, for whatever reason, the jury rendered a decision in favor of the Kansas City Royals. A lot of times in law, we talk about somebody who has a home field advantage because, the lawyers live in that city and the defendant lives in that city and everybody knows the defendant. This is one of those cases. Everybody knows who the Kansas City Royals are. And this was tried at a time when the Kansas City Royals were doing quite well. So, the Royals' popularity as a team may very well have figured into the way this all came down. So, with that said, it's an interesting case. Hopefully it explains the doctrine of assumption of the risk, because it really is a pretty simple doctrine. If you go somewhere where there are inherent risks, for example, if you go to the Indianapolis 500 and a tire flies off of a car and hits you when you're sitting in the front row, that's an inherent risk of going to the Indianapolis 500. All of those things make up the assumption of the risk doctrine. So I hope this has been helpful. I hope this explains it for the person who asked if I would make a video on the doctrine of assumption of the risk. If you have the time today, please take a moment to think about someone else and do something nice for them. It doesn't have to be a big thing. It can be a little thing. But do something nice for somebody. It really will make your day a better day. Thanks again for watching. Have a marvelous day. We'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.